Okay, so welcome to our webinar this morning. We're just getting ourselves ready to go. Today we're going to be doing a webinar on the impact of flooding on tenancy arrangements, hints and tips for helping tenants navigate the aftermath. My name is Penny Sullivan. I'm one of the sector sustainability team here at Community Legal Centres Queensland. We'd always like to begin with acknowledging the traditional owners of the land on which we're holding today's webinar. In Meanjin or Brisbane, they are the Turrbal and the Yagara people. We pay deepest respects to elders past, present and emerging. As this webinar is being viewed by people across Queensland and Australia, we also pay respect to the traditional owners throughout the country. We recognise Aboriginal and Torres Strait Islander peoples as the traditional custodians of the lands in Australia and recognise their continuing connection to land, water and culture. We acknowledge the stories, traditions and living cultures of Aboriginal and Torres Strait Islander peoples and commit to fostering a culture of learning from and working with First Nations peoples in the spirit of reconciliation and access to justice. We extend a warm welcome to any First Nations people listening today. So today we're really pleased to welcome Justin Ray-Thierry, who's a Senior Associate in the Commercial Property team at Hopgood Gannon Lawyers, to talk to us about the rights tenants may have where their tenancy has been impacted by the recent flooding and some tools that may be available for tenants to try and open up a line of communication with their property manager or owner about the needs they have post the flooding event. I'll just let Justin tell you a bit more about himself when I hand over in a moment. But before I do that, just some quick housekeeping. The webinar today is being recorded and we'll have that recording available to download later today or tomorrow, and I'll send the link out to all the participants. A link for the PowerPoints was emailed out to everybody this morning. You can download it from our website, and the slides are also available from the handout section of the GoToWebinar control panel. We do encourage you to ask questions. You can type your question into the question box on the control panel and I'll read your question out. We'll hold questions till the end of the presentation, but feel free to type them in as you think of them. So that's it from me. I'm going to hand over to Justin now and I'll talk to you again at the end of the session. Thanks so much, Justin.
Thanks, Penny, and welcome to everyone listening in today. Always nice to be listening on a Monday lunchtime and it's a short week. And if you were one of the ones that managed to look at a calendar early on in the year and realise that we've got 4 short weeks coming up and you booked some leave in, I salute you, because I certainly did not do that at the time, and I regret it now. But anyway, so my background is I've been practicing at Hopgood Gannon for over 10 years now, and I specialise in the commercial property in that area, and I do all areas of commercial property practice. Now, while that is predominantly dealing on the commercial side of things, we do often have to sort of touch base and investigate issues around residential tenancies as well. So there's a fair bit of crossover there, and that's why I've happily volunteered to do this webinar today. All right. So I'll just show you. So here's a quick breakdown of what we're going to touch on today. So the first 2 agenda items there, the first one is looking at what tenants can do in situations where their home or site's no longer habitable and they're looking to exit from a tenancy arrangement. Second agenda item will be looking at a circumstance where there's been a natural disaster and the tenant wants to remain in the property and what sort of relief will be available to the tenant in that situation. Then we'll quickly touch on the rental housing stock shortage and some considerations around that. We'll go on to body corporate and community living considerations. And sort of more specifically on that agenda item, we'll look at some situations where tenants have not been properly notified by building managers or body corporates about flooding issues in their building, and there's subsequently been some issues. Then if we do have time at the end, I'll touch base on just some considerations for businesses and operators who are operating under commercial leases and who may be dealing with some impacts of flooding there. Okay, so this first agenda item. Now, the applicable legislation that governs a lot of these issues for residential tenancies is the RTRA Act, which is up there on the slide. Now, for the purposes of this part of the webinar, I'm going to refer to and use the term property, but I just wanted to point out that for the purposes of the Act, property, in inverted commas, also governs movable dwellings and caravan park sites. So where I am mentioning property and talking about those things, please view that term interchangeably because it does apply across the different contexts. I'm also probably just going to use the flooding as the most recent example of a natural disaster, and yeah, I'll refer to that probably quite regularly, but I just want to make the point too that shouldn't detract from any of these comments, and these comments will apply generally to where there's a natural disaster. Right, so the starting point for a tenancy agreement is that it does not automatically come to an end when the property is rendered non-livable. Rather, it will only come to an end if one of the following happens. 1, the property manager / owner and tenant agree in writing. 2, the tenant gives the property manager / owner a notice of intention to leave, which is a Form 13. The property manager / owner gives the tenant a notice to leave, which is Form 12, or QCAT makes a termination order. So what I want to focus on here is, one, obviously circumstances of non-livability, but secondly, situations where a tenant can give a notice, because I think that's going to be more important than when the landlord gives the notice, and I suspect that many landlords would generally try to avoid giving a notice where they can. So, under the relevant section, notice must be given within 1 month of the event causing non-livability. Either party to a tenancy agreement may give notice to end the tenancy because the premises either 1, has been destroyed or made completely or partially unfit to live in, or 2, no longer may be used lawfully as a residence. Also, please be aware that under the Act, if a tenant is aware of damage to a property, the tenant must give notice as soon as practicable of that damage to either the owner or the property manager. So what I want to focus on in the relevant section, firstly, is the notice period of 1 month of when the event causing non-livability arises. So the first comment I want to make here is just bear in mind that this legislation is consumer protection legislation. So it's designed to protect the tenant in a residential letting scenario. And so if you're going to give advice or just sort of tips to any tenant, a good starting point is that an interpretation that is more favourable to a tenant is going to be generally viewed as the correct interpretation. I'm not saying that's always the case, but it's a really good starting point and something to keep in mind. So when we talk about the words event causing non-livability, I think it's important to consider those words on a case-by-case basis. So don't simply look at it in a narrow context where the floods, for example, they occurred at the end of February, and then a tenant has 1 month from when the actual date the floods occurred to give this notice under the section, and that's too limited of an interpretation. I think you've got to view the circumstances as a whole in each case on a case-by-case basis. And for example, the flooding event may have occurred and a tenant, may have suffered damage to their property, but they might, post the flooding event, still have a reasonable belief at that time that they can continue occupying the premises as a residential property, and then they carry on to do so. But then it's only after a period of time after the flooding event has occurred that they then realise that it's not realistic or it's not reasonable for them to actually stay in the property. And then it's at that point in time, in my view, that the event causing non-livability arises. And then as a totality of all the circumstances, they can give a notice that they need to end the tenancy. I also think it's important too in legislation, and I've underlined it on the slide, just to think about the words made completely or partially unfit to live in. Again, I think that's there's a pretty broad context to argue in there too, particularly around the words partially unfit to live in. So also please bear that in mind if you're ever looking at this section and providing any advice. Now, where notice to leave on grounds of non-livability is given, the relevant tenancy agreement ends on the date the notice is given. However, the person giving the notice, i.e. the tenant, may choose a longer period if they desire. This is just some more general, looking at some more general obligations under the Act. So if an agent, so a property agent or property manager is not contacted by a tenant after a major flood event, but the agent is aware that the property is located in a damage affected area, the agent should endeavour to make contact with the tenant to determine if any damage has occurred. In the event the agent is unable to contact the tenant, then the agent should attempt to conduct an inspection of the property as soon as practicable. Agents should only inspect a property if it is safe to do so. Under the Act, if access is available to the property, no notice is required for a property manager who may enter in an emergency or for reasonable grounds to protect the property. And then agents should also prepare a detailed report following an inspection of the property, including detailing all the damages and taking photographs of any damage to keep accurate records of that. Now, I point these obligations out just because, one, if tenants have got property managers that aren't doing these things, then they should really get onto the property manager to make sure they do these things so that everything's properly documented and recorded and there's no issues at the end of the tenancy as to what damage has arisen during the tenancy caused by the tenant and then what actually has arisen due to the flooding or other natural disaster. And I think it's also important just to note these obligations generally too, because if you're dealing with a property manager who's not meeting these obligations under the Act and requirements, then that can often be a bit of a negotiating tool, just a bit of something that a tenant can latch onto if they need to go onto the landlord and have some negotiations regarding rent relief or other negotiations. So now I'm going to consider where the flood event or natural disaster has occurred and the tenant is still going to reside in the property. So as a starting point, until a notice is given to end a tenancy, a tenant is obliged to continue paying rent, even if the tenant has been evacuated from the property. With respect to bonds, there is no provision for emergency release of bonds to tenants who have been adversely affected by a natural disaster, unfortunately. And then the major section that you want to focus on these situations where tenants are back living in a flood affected property, that's section 94 of the Act. So where a property is damaged not through the fault of either party, the parties may come to an agreement to reduce the rent during an evacuation time or for the period that the property is damaged. Now, I need to stress any such agreement should be made in writing. A tenant may be able to negotiate a rent reduction with the property manager while the property is being repaired. Rent reductions may occur if 1, the property is significantly damaged to the extent where its standard or amenity has decreased substantially, and or 2, services or facilities provided under the tenancy agreement, such as car parks, pools, or a laundry, are not available. Now I want to focus in on the references in that second sub-point to services or facilities provided under the tenancy agreement not being available. So those services or facilities may extend to include tenants' access to power, water and plumbing. And even in those cases where you might not have access to power, water or plumbing, definitely landlords, but also some tenants might view that the property still remains livable, in which case it's very important to consider these rent reduction provisions. So just to dig into that a bit more, as an example, if a tenant can only use certain areas of the property, or the property is without amenities and services for an extended period, or also if the tenant has to seek alternative accommodation because the property is too damaged to live in, but they don't want to end the tenancy agreement, then rent relief or rent reduction may be appropriate under that second limb on the screen. And I point this out now, and I make the comment now that it might be particularly important to keep the tenancy agreement on foot and seek a rent reduction, and it might be 100% rent reduction rather than end the tenancy agreement, because there is such a shortage of rental properties out there at the moment. So you could run into a bit of an issue where the tenant ends their tenancy agreement, and one, they then struggle to find alternate premises to rent, but two, even if there's some dialogue with the landlord and they say, well, we'll end the agreement and then we'll enter into a new agreement once the property has been repaired, then there could be a higher risk that that new agreement is presented with a higher rent. And so obviously that poses difficulties for the tenant then. And there's nothing stopping a landlord from doing that in that scenario, because it's a new agreement. The tenant can present it on whatever new terms the landlord can present it on whatever new terms the landlord deems necessary. So I think it's important, if you're speaking to tenants, to sort of point that out and try and gauge whether they really want to stay in that property on the current terms of the agreement, or whether there might be some scope to move elsewhere or do a new agreement in the future. All right, so I just want to give a few examples of where you can trigger those rent relief provisions under Section 94 of the Act. So just to run through a few on the screen, the property is still without power or water. The property does not have a functioning or has a reduced functioning sewage system or other plumbing system. The downstairs of a two-level property, for example, a Queenslander, is unable to be used for its intended purpose, such as for car parking, laundry or storage. Or bedroom or other rooms on the downstairs level are unable to be used for their intended purpose. In this regard, it can be important to consider the online for rent ad for the property, see how the property was initially advertised. For example, if it was advertised with the downstairs of the property being able to be used for certain things such as car parking, a laundry or storage, or advertised having a certain number of bedrooms, and now those a certain number of those bedrooms can no longer be used due to the flooding, or the whole of the downstairs can't be used and you can't park your car there anymore, or use the laundry or store things under there anymore, that's definitely going to trigger the rent relief provisions. In a community living situation, some parts of the complex might still be inaccessible or unusable. For example, the common property amenities like a gym or a pool. Again, it can be important to consider the online for rent ad for the property, and also see if there's reference to those relevant common property amenities being included for use with the unit or townhouse or whatever it is that you're renting. And generally they are. Usually, the ad's quite flamboyant and very wanting to portray the property in the best view. So generally they'll refer to all those things. And also on the community living space, the basement car parking, if that was to remain unusable due to flood damage, or if the lifts are not operating due to flood damage, or there's a reduced capacity in the operating lifts, then again, in my view, that's definitely going to trigger that second limb of the rent reduction provisions dealing with services and facilities not being available. So just quickly touching on property repairs, who is responsible? So the starting point is the landlord must repair a property if it is damaged, as a landlord is obliged to ensure the property is fit to live in good repair, and complies with any law regarding health and safety. And of course, that's in the context of a natural disaster where the damage is not caused by either party. A tenant is responsible for removing or cleaning their own possessions within the property. Where a tenant's own possessions have been damaged or destroyed as a result of flooding, then the tenant's first point of call should be to the tenant's contents insurer. I'm still in the repairs space. Just wanted to touch on the relevant section in the Act dealing with emergency repairs. So Section 214 of the Act defines emergency repairs as a long list of things, which are on the slide there. And I've highlighted a few that are likely most applicable in the natural disaster scenario. So just briefly, most people know this information, but I just want to touch on it again because it's just relevant to make sure that tenants can get emergency repairs carried out as quickly as possible. So under Section 216 sub 1 of the Act, a landlord can nominate a person to act on their behalf in arranging emergency repairs, or can nominate a person to conduct the emergency repairs. Sub 2 provides that the nominated repairer can be stated in the tenancy agreement or in a separate written notice given to the tenant. The agreement or notice must state whether the nominated repairer is the tenant's first point of call, or the first point of call for notifying the emergency repairs. Any change in a nominated repairer must be advised to the tenant in writing. Under Section 217, the tenant may notify the nominated repairer of the need for emergency repairs if they are the tenant's first point of contact, or if the tenant has been unable to contact the property manager or owner after making reasonable efforts to do so. Under the Act, if the tenant has been unable to notify the property manager or the owner or a nominated repairer of the need for the emergency repairs, or the repairs are not conducted within a reasonable time frame, then the tenant may at their own initiative arrange for a suitably qualified person to attend to the repairs or apply to QCAP under the Act for orders in relation to the repairs. Now, what is a reasonable time frame for emergency repairs to be conducted? That again will need to be considered on a case-by-case basis. And in particular, given the current difficulties most people are facing with being able to engage a tradesman to do repair work, that's going to factor into that reasonable time frame. And it may be that what is a reasonable time frame currently probably a bit longer than what it was pre the flooding in South East Queensland, and probably sort of pre the COVID-19 situation, because tradesmen are just seeming to get more and more busy and a lot harder to get a hold of. Under Section 219, a tenant cannot incur emergency repair costs in excess of 2 weeks' rent under their agreement. So that's important to note. Now, if the tenant is required to go through the process of either incurring the cost or at least just getting the tradesman out to do the emergency repair because they haven't been able to arrange it through the property manager, the tenant can seek either reimbursement from the landlord for the costs of the work that was carried out, or they may require the landlord to pay the repairer directly. So the tenant must provide the landlord with documentary evidence to support the demand for the reimbursement or the payment to the repairer. And if the landlord does not reimburse the tenant within 7 days of receiving notice of the reimbursement, then the tenant may apply to QCAP for an order seeking payment of the sum incurred. In that scenario, I guess the advice to give to tenants is to try and avoid having to pay the cost at all. If they have to go down that path and have the person come in off their own bat, then you really want to try and have the landlord reimbursing that cost directly to the repairer, and then the tenant not having to fork out any money, because you really want to avoid having to go down the path of then chasing the landlord for that money if that's the case. Now, just from sort of the property manager side, emergency repair requests they should be treated with the utmost priority. So in the perfect world, you shouldn't have to go through the scenario of the tenant having to arrange it. The failure to address emergency repair requests in a timely fashion could expose a property manager to some claim or allegation that they haven't been acting in accordance with their obligations. So again, that's probably just a point just to keep in the back of your mind. If you're looking at a scenario where a tenant's had to arrange their own emergency repairs or something like that and they're seeking reimbursement. Just quickly, on a couple of other things, particularly arising from the flood impacts. If issues with vermin in the property have arisen after the flooding, it is likely that the landlord will be responsible for treating the issue. And then secondly, looking at mould, responsibility for mould will depend on how it originally appeared. So if it has appeared in the property sort of as a result of the flooding and as a result of some water ingress into the property, then it's likely the landlord that will be responsible for removing it. Where it gets more tricky though is where there's been some existing mould in the property and then the impacts of that flooding have extended the extent of that existing mould. That could be a bit harder to try and place the responsibility on the landlord to resolve the issue, but I would suggest that you just have as much sort of photographic evidence of what the mould looked like pre the flood event, which could be in the entry condition report, and then documenting what it's like post the flood event so that there's some sort of evidence to show the difference. All right, touching on insurance. So generally, landlord insurance will not cover the tenant, the damage to the tenant's possessions or the cost of replacing food resulting from flood. These matters are the responsibility of the tenant and may be covered by their own contents insurance. If there's a home office being used at the property, then a tenant may be entitled to make a claim with their insurer in relation to any impact that the flooding's had on that home office situation, their ability to conduct their work. But again, that's all going to be subject to the tenant's own insurance policy and what coverage that has. Just want to touch on disputes as well. If there's any dispute that arises from the subject matter that we're discussing now, then either party may lodge a dispute resolution request, which will live in the QCAT jurisdiction under the RTRA Act, which is the relevant jurisdiction to hear disputes. Ultimately, in my view, you only want that jurisdiction enlivened as a last course, really. You'd really hope to be able to do some sort of deal or reach some sort of arrangement with the landlord or the property manager before you go down that path. I've got a dot point down the bottom there, and that touches on my next slide as well. Again, it's really important to remember that an existing tenancy agreement will be subject to its existing terms, including the rules about the rent not increasing outside what's permitted under the Act. So where you can, it's really important to try and keep that on foot, particularly if it's a long-term agreement, and avoid the tenant having to move and enter into a new agreement. And again, that touches on this next point as well about rental housing stocks shortage. Because there is such a shortage out there at the moment, you really want to avoid tenants where they are sitting where they are, having to go back out into the market and finding new rental premises. But just quickly, I'm just conscious of time, looking at this rental housing stock shortage heading quickly, it's a responsibility of a tenant to find alternative accommodation if that's what's needed in a natural disaster scenario. Generally, compensation is not payable to a tenant by a landlord if the tenant is required to seek accommodation in emergency housing as a result of a flood. However, there are tools under the Act, as we've just discussed, in order for a tenant to seek to end their tenancy agreement or otherwise seek a rent reduction under their existing agreement and to keep that agreement on foot in order to reduce the financial implications of the tenancy agreement on the tenant. Tenants experiencing hardship should check if they qualify for any of the following government assistance or grants. Now, I'll put a bit of this information in the slides. I won't run through it because it's in the slides and you can look at it for your future reference if you need to. But yeah, just sort of summarised a few of the government payments that can be made and a few of the rate tunings, I guess you would call them, that are available if a tenant needs to seek those out. All right. Now, moving on to the body corporate side of things. So the body corporate community living considerations. So we'll start with just touching on body corporate insurance. So in most cases, the body corporate must have building insurance and public risk insurance for the common property and assets. Different insurers and policies can contain different levels of cover. A tenant's first steps where they're in a community living situation and they've had property damage, their first steps might include locating a copy of the relevant policy for the scheme. The tenant may wish to contact the body corporate or the on-site manager or the body corporate manager as necessary to get a copy of that. Checking that policy for the extent of its coverage. And then thirdly, contacting the tenant's own insurer or broker to discuss any damage and the process for lodging a claim in the context of that body corporate insurance for the common property and assets. I'm not saying there will always be a bit of crossover, but depending on the damage or the scheme, there might be a bit of crossover between the tenant's own insurance and the body corporate insurance. And that's why it's important where a tenant can to discuss it with their insurer. So what will happen where, for whatever reason, the body corporate insurance does not cover the flood damage? Well, body corporates and their members will need to cover the cost of restoring the scheme to a good and structurally sound condition if the damage is not covered by insurance. And in general, lot owners will each need to cover the costs of fixing their own lot where the damage caused is within the boundaries of their own lot, and that's defined, depending on what sort of plan and scheme exists. So timing for repairs. A body corporate must act reasonably and perform certain maintenance duties under the applicable legislation, which is the Body Corporate and Community Management Act. The body corporate may fail to meet its obligations if it does not repair damage or rectify maintenance problems within a reasonable time of becoming aware of the problems. And a couple of examples there are reinstating the basement for car parking, reinstating common property facilities for use, or having a lift repaired. However, and I touched on this before, it's critical to keep in mind that in the aftermath of flooding, contacting and arranging for visits by tradespersons is a big challenge. So that's going to have an impact on what is a reasonable time in order for the body corporate to meet its obligations to repair the damage or rectify the relevant maintenance problem. And there's unfortunately not much we can do about that. So again, it's probably going to mean that a reasonable time for the body corporate to do things is a bit longer than what it would have been in the past. Looking at lot owners specifically, they have a responsibility to repair their own lots where the damage is within the boundaries of their own lot as soon as practicable. Again, though, the words as soon as practicable are going to, again, they must be taken in the context of how quickly tradespeople can be organised to carry out the works. Separately to this position under the BCCM Act, none of these obligations cut across or impact the tenant's ability to seek a rent reduction under the RTRA Act, and that should be very much at the forefront of your mind. So where they might be chasing a body corporate or a lot owner to do damage, to repair damage that's to the lot or to the body corporate scheme more generally, and that's taking a long time to be followed up, and there doesn't seem to be much action on that front of things. So long as the tenant has a proper claim under the RTRA Act, the tenant can make a claim while the repair work has been organised for a rent reduction. So the two work together in that regard, and that's important to keep in mind. So looking more at some specific examples here, so looking at the situation where tenants in a community title building have not been notified by their building manager or the body corporate that flooding issues may arise in relation to the property. So the starting point is ultimately a tenant living in a community title building does so at their own risk, and there are some inherent risks associated with that, especially where you're in a high-rise building and the only real appropriate means of access to your floor essentially is the lift, and you're heavily reliant on a lift. The first point of call for an affected tenant should be to the on-site manager or body corporate, and they should be put on notice that the tenant or the owner-occupier is unable to leave their property due to whatever the relevant issue may be. So, for example, the lifts aren't operating. You should look to open up a line of communication as a tenant or an owner-occupier as soon as possible with the body corporate or the on-site manager to discuss the impact that the relevant issue, for example, the lift's not working, are having on your ability to live in the building and to live in your property, and see whether you can reach an alternate arrangement regarding certain aspects. For example, there's been a bit in the press about certain buildings that have been badly affected by the flood, having people arrange for a daily food pickup and drop off, or having someone who can walk the pets in the building. So yeah, just think about those things. Again, lifts are a big thing post the flooding, and the big thing to think about there is, in terms of their repair, the body corporate does have a reasonable time to repair any issues with lifts. And I'm no expert on lifts, but I think there's only a few sort of professional contractors and qualified contractors that can do lift repair works. And if they're all being called out to jobs, it's just going to take longer. And that's the unfortunate reality of it. And that just needs to be taken into account as a whole. One point here is where lifts have not been damaged, but during the flooding event they were turned off or something, where the body corporate had a legitimate reason to turn the lifts off or to stop access to them for a period of time because there was a reasonable belief there'd be damage to the building or to the lifts caused by the flooding. And that's also okay, because ultimately the body corporate has a responsibility to ensure the maintenance and repair of the building generally and the body corporate assets, and that extends to taking any reasonable steps that the body corporate believes is necessary to protect any of those things in the circumstances. So looking at the other example about tenants not being told by building managers or body corporates that the basement car park may flood. So again, a tenant living in a community title building does so at their own risk. And it's quite unfortunate that that's the case, but it's the stark reality of it, and particularly so, I guess, for inner city buildings where you do have proximity to the river, and you could probably reasonably foresee that the basement may flood. In those cases, the first point of call should be to the tenant's insurer or insurance broker. There's no positive obligation on a building manager and body corporate to give notice that a basement car park may flood. And in many cases too, the building manager or the body corporate may not actually be aware of the risk if the building is new and it hasn't been through a flood event before. Or it could just be the case that the body corporate management has changed since the last major flood event in Brisbane in 2011, and because of that, they just don't have that historical knowledge to be aware. Again, the tenant if there's been damage to a basement in their car, and to items in a basement or to a tenant's car, the starting point should be the tenant's own insurance. As I mentioned, the body corporate insurance only covers common property and body corporate assets, so it's unlikely to extend to the tenant in this scenario. Where a building manager or body corporate may have made a representation or statement regarding a building or a basement not flooding, and then it actually did in fact flood, then in those circumstances, the building manager or the body corporate may have breached some sort of statutory obligation about, misleading or deceptive conduct. But even if that's the case, it's going to be a costly exercise and of no real direct benefit for a tenant to pursue its options down that path. The better option there is where a tenant can make a claim on their insurance, that they just make that claim and have it progressed as quickly as they can. I've got a couple of minutes, so I'll just touch on leasing issues for small businesses and sole traders, and this is outside of the context of the RTRA Act. Generally, in those scenarios, the tenant or the sole trader will be operating their business under either a commercial tenancy agreement or a more formal Form 7 lease. And in that case, what options may be available to the tenant is really going to turn on the terms of the tenancy agreement. So it's important to ask the tenant to provide a copy of their agreement, or otherwise to review a copy of their commercial tenancy agreement or their Form 7 lease to be able to determine what their situation is. Now, there's some people talk about force majeure clauses and things like that, and force majeure clauses being able to give, a right for a party to terminate an agreement. Generally, in commercial leases, they contain a general or broad force majeure clause. So rather, they'll contain a clause which is called a damage or destruction clause. That'll apply to the premises or the centre within which the premises is situated. And that'll apply where there's physical damage so as to render the premises or the centre totally or substantially unfit for the use and occupation by the tenant. In those cases, there's generally a regime for how a tenant may make a claim under that damage and destruction clause, and it's generally for an abatement of rent and abatement of the tenant's repair and maintenance obligations. So if there is one of those clauses and the tenant wants to make a claim, they should really read that clause carefully and then follow the steps under that clause, which generally includes giving a notice, and they'll also have to make an assessment based on the impact of the flood, the extent to which they want an abatement, whether it's 100% abatement or something less than that. But the same examples that we gave on the residential tenancy side would apply, if the commercial tenancy is without power or still without power, or there's a period of time where it was without power or water, then there's definitely scope of most general damage and destruction clauses and commercial leases for an abatement to be sought for the relevant period. Yeah, that's just my slide there. One other point on this is that there may also be some other grants or some other relief available for sole traders or small business operators. So it's important for the tenant to consider whether it might have the ability to claim a grant to the government for any loss or damage that it's suffered. Otherwise, that concludes my presentation, and I'm now happy to take any questions.
Thanks so much, Justin. That was really informative, and I'm sure everybody really appreciated the detail that you were able to go through there. Could I just get you to pop yourself on mute while I'm talking? Apparently there was a bit of feedback coming through at the start of the session. Hopefully that's stopped now. So I've got a question here from Jessica. Where rain has entered a lot in a CTS because of defective building work or from the above level, is the owner of the lot liable for repairing the damage or the body corporate? Thanks, Justin.
Yeah, so if it's a structural issue or an inherent defect, the starting point will be the body corporate. So the lot owner in that case should follow up with the body corporate, make them aware of the issue, and then sort of follow it up from there. because that would be an issue going to the heart of the common property or the body corporate asset.
Great. Okay, hopefully that's answered your question, Jess. If there are any other questions, feel free to pop them in the chat, people. We've got Justin just for a little bit more time, so it would be great if you have any more questions. I just had one that popped up for me, and it's probably a bit of a piece of string question, but you mentioned a couple of times that given the trades shortage, it's going to be difficult to sort of quantify what a reasonable amount of time is for repairs. What's your view about that? I'm sort of mindful, certainly for vulnerable tenants, that they can be in a situation where, you know, that can go on for a long period of time. What does reasonable feel like? Can you tell us about that?
Yeah, look, it's real. I think the first starting point is to assess how critical the repair that needs to be done is. So obviously, if it's more critical, what a reasonable time is going to be less. And look, I'd love to be able to put a time frame or days or months, but really, it's going to depend on the critical nature of the repair. And look, if a tenant could, I'm just thinking of ways that you could sort of try and put yourself in a stronger position as a tenant. Like if it's something quite critical, it might be worth the tenant or someone trying to get in contact with someone, a tradesperson, just generally, or a few of them, just to suss out whether that trade, you know, explain the issue and then get something from the tradesperson in writing or something as to how quickly they could attend to that for the tenant. And then they could use that as a bit of an ammo to go back to the landowner or the property owner and be like, hey, this issue, I got in touch with this person who said that they can do it this quickly. This is what I expect, you know, this is what I expect the time frame to be and what I consider to be a reasonable time. And, you know, I'm going to hold you to that. Maybe that's the better approach to trying to go after it rather than sort of sitting back and trying to guess what a reasonable time is.
Yeah, okay, and keeping in mind your note of caution about avoiding the tenant paying for the repairs themselves and seeking reimbursement as far as possible, given that.
Yeah, that's right. Does that help? I'm thinking maybe try and use something external to try and use as the reference point for what a reasonable time might be.
Yes.
So you're going out and just inquiries yourself as a tenant without paying money or anything like that. But generally, you know, just seeing if they can give you a quote or something for a job and a time frame.
Yeah, look, I think that's really helpful and just useful to try and put something a little bit more concrete and practical for people to be able to follow through with for the people they're assisting. Lyndall's got a comment here, which is rent reduction applications usually speed things along. Thanks, Lyndall. Okay, well, we don't have any more questions coming through at this point, so we might wrap things up there. And what I would encourage people to do is if you do have further questions for Justin, you can always pop an email through to me and I'm happy to touch base and get back to you. So we might wrap things up then. And our big thank you, Justin, for your expertise and knowledge today, your time in sharing that with us and our sector. It's really very much appreciated, particularly at this really difficult time when so many centres are dealing with people in really desperate straits. So thank you very much for your time. Just before we finish up, I just remind you to please complete the feedback survey that will pop up on your screen once the webinar closes. It's really helpful to us to help improve our webinar program and also really useful for our presenters just to be able to see how their presentation has been for you. Just a little extra reminder to everyone that don't forget the CLCQ conference, which is coming up on the 11th and 12th of May here in Brisbane. We will be running some sessions online as well. Tickets are starting to sell pretty fast, so make sure you secure your place for that if you're interested in coming along. Justin, I might just get you to stay on for just a minute or so while we finish the back end of this, but for everyone else, thank you so much. We'll look forward to having your company again for another webinar soon. Thanks, everyone. I'm just waiting for people to jump out, Justin, and then I just need your help closing this down.